Good morning, everybody. I see from the attendance records that we're having participants continuing to join at quite a fast rate. But I think for those of you who are on time, let's kick off. The first thing I want to do is welcome you all. A really warm welcome to the extent that we can be warm using this method of delivery. It's a further in our series of virtual panel discussions on the legal and regulatory issues facing employers in the current global economic environment. My name is Chris Todd. I'm a partner in the Bowmans employment practice. I'm very happy that you're able to join us today, and even though we're not able to see you face to face and engage directly, we're, I hope, going to be able to have a dynamic discussion today. Just to run through a few housekeeping matters, just for good order and to maintain the quality of sound, participants are all automatically on mute. That the chat functionality has also been disabled, but we do want you to ask any questions that you have during the webinar. To do that, please will you make use of the Q&A tab at the bottom of your screen. And I'll be monitoring that. I'm facilitating the discussion today, and I will do my best to put whatever questions you put into the Q&A tab. I'll do my best to put those to the panel during the session and to get answers for you. We're also recording the webinar, and a copy of that recording will be made available on our website later today, and that is at www.bowmanslaw.com. 6 weeks ago, we held a panel discussion, and that was right at the end of March, just a few days into the South African hard lockdown, or level 5 lockdown, as we now refer to it. We had a panel discussion on the enormous challenges that faced employers right at the start of the lockdown. And we confronted some of the stark choices that they were facing as they experienced forced closure of their businesses and sudden instant disappearing, freezing of their revenue. And we talked about really some of the hard choices they had to make at the time. And we hope very much that most of our clients have, through a combination of sensible measures and perhaps resilience, managed to survive the economic meltdown thus far. The topic today, perhaps more optimistic. We are looking forward, businesses starting to plan their return to their usual workplaces, thinking of the possibility and the timing of resuming operations. But the legal and regulatory terrain is no less fraught with conflicting interests and challenging decisions. There's an overwhelming economic imperative and business imperative to get back to production as quickly as possible. But that presents stark public health risks, many of which employers will now be grappling with and working out how, for the first time, they required very actively to manage public health in the workplace, and certainly in a way that they never have had to before. To discuss these topics, it's time for me to introduce the panel we have to make sense of the legal, regulatory, and best practice, workplace best practice issues that we're all confronting as employers as we plan and hope for a return to the workplace. Let me start with our two special guests on the panel. We're particularly delighted to be able to introduce and be joined by two colleagues from the international law firm, Freshfields Bruckhaus Deringer. They've kindly agreed to share their insights from other parts of the world. Nicola Jones is the only person who is actually in the office today, in her office in Hong Kong. She's an associate seconder to Freshfields' Hong Kong team. Thank you very much for joining us, Nicola. And David Mendel is a senior associate in the firm's London practice and spent yesterday reading hot off the press a swathe of regulations published there, as in the UK, the government starts to try to grapple with and encourage a return to work in many industries. In South Africa, we are joined by our head of our employment and benefits practice, Lusanda, Raphulu. And I'm just wanting to see if Lusanda is there. She's temporarily disappeared from my screen at least. Then we also have our partner, Talita Laubscher, who has been very much involved in a whole range of ways, both advising clients, but also in trying to get some sort of order into our COVID TERS benefit, as it's known. And Talita was rather alarmingly commenting just before we started that we might expect some changes there in that benefit. But thank you very much for joining us, Talita. Nadine Mather is a senior associate in our Johannesburg practice, and also very much an expert on questions not only generally around the COVID regulations, but is going to be talking to us today particularly about how information is protected in this new world. So let me kick off, if I may. Nicola, you are first up. You're furthest away. You're ahead of us in time. I think it's 4 o'clock in the afternoon with you. And you're also ahead of us in the COVID cycle in terms of when it started and when people are returning to work. Can you just give us a broad overview of where things are in Hong Kong and the surrounding countries?
Yeah, sure. Thanks, Chris. So I think we can certainly say that we're ahead of the curve here in Asia, but it is still a bit of a stretch to say that we are fully back to normal, especially with some jurisdictions in Asia, for example, Singapore, still in the middle of a full lockdown. But definitely here in Hong Kong, we do seem to be emerging from the pandemic crisis. And so to perhaps put the Hong Kong situation into a little bit of context, I just wanted to run through some of the key dates in the Hong Kong chronology. So we saw the first confirmed COVID-19 case in Hong Kong on the 23rd of January. And quite quickly after that, the Hong Kong government moved to limit travel. And we also saw most employees quite quickly moving to working from home arrangements. But Hong Kong never saw a strict legal lockdown enforced by the government. And so private employers were following what the government was doing in relation to public services and their own civil servants. And so employees were never strictly prohibited from going into the workplace, but instead were being asked to do so or required by employers to work from home. And it wasn't until actually March, where there was a second spike in cases, that the Hong Kong government moved to introduce stricter social distancing rules. And so that was the first time we saw in Hong Kong certain businesses having to close, but a fairly limited list. So gyms and saunas, bars and clubs and that type of business forcibly closed, and rules banning large public gatherings. But there were certain exceptions for the workplace. So it's still possible to have meetings internally with sort of a larger group of people attending. Those stricter social distancing rules were relaxed at the end of last week, so less than 2 months after they were introduced. And the government now is resuming public services and asking civil servants to return to work, which in turn means that we're seeing private employers mirroring that and following suit, so that there's a very clear trend here now in Hong Kong of employees returning to the workplace. But employers are being cautious about it. There is still that lasting risk or fear around contracting COVID-19, and so employers are being cautious and implementing a return to work in a very gradual phased approach. So either with split teams, an in and an out team, which change over at the end of each week, or with kind of a very phased reintroduction to the workforce, so 20% increasing to 50, 70 over a sort of a long period of time. And I think perhaps the last thing I'd say on Hong Kong before handing back to you, Chris, is on the international travel, because of course we're all interested in this from a personal perspective, but it also has an impact on business operations. So the situation currently in Hong Kong is that the border still remains closed to non-residents, and any returning residents have to undergo a compulsory 14-day quarantine, albeit that can happen at a private residence. But returning residents have to wear an electronic tagging device to make sure that they don't leave the residence that they're staying in for the quarantine period. and those returning residents from high-risk areas, so the US, UK, continental Europe, have to undergo a COVID-19 test when they return to Hong Kong. And those international travel restrictions don't look like they'll be lifted anytime soon.
That's brilliant, Nicola. Thank you very much for that. Can you just, before I move on to the UK, just talk a little bit about the geographies around? In other words, is this a uniform experience? Do we talk about Asia or Southeast Asia as going through the same cycle at the same time? And then briefly as well, you mentioned that the lockdown hasn't been heavily regulated. Can employers go back to work? You're not wearing a mask, maybe you wouldn't have to. One of the things that we're grappling with in South Africa is the extent to which employers are going to have to regulate the workplace itself. Just any brief comments on those 2 points?
Yeah, to the first point then about whether this Hong Kong is consistent with the other jurisdictions in Asia. So China has definitely seen a gradual opening up, and it does seem that employees are returning to work there. So perhaps similar to Hong Kong, Vietnam too is also opening up, and so employees are sort of increasingly returning to work. And I think there are only 2 or 3 areas of Vietnam that are high risk areas still, and so are still under stricter sort of lockdown measures. But then contrast that with Singapore, which is still sort of in the middle of its circuit breaker lockdown. And so although Singapore at the outset was doing very well in terms of the virus and handling it very well, it saw a real second spike in cases, which meant it almost had to take a step backwards. And they are then therefore a few weeks, months further away from return to work. So I don't think we can say that all of Asia is in the same situation at the moment, but Hong Kong is perhaps more similar to China at this stage. The second point is an interesting one. And so Hong Kong, unlike some other areas in Asia, so Singapore, China, have taken quite a relaxed view, or relaxed response to hard regulation or hard laws about employer obligations in terms of facilitating a safe return to work, and instead have issued guidance, and private employers have then kind of looked at what the government's been doing in relation to its own civil servants and public services. But it's meant that without that black and white, very clear guidance or rules issued by the government, each individual employer in Hong Kong has had to really grapple with what this means for them and their business. And so conducting kind of very specific risk assessments, looking at their own workforce, location of the workplace, high risk employees, the nature of the work that's being carried out, and really think about what that means for them in terms of their own current employer duties, health and safety, ongoing duties of care to employees, to work out how they can ensure the safety of employees at their workplace. So like you say, whether they should be issuing masks, hand sanitizers, should be doing temperature checking on entry to the offices, enforcing social distancing rules. So certainly in Hong Kong, there hasn't been any strict legal rules imposed on employers, which is perhaps different to what's happening in China and Singapore, where there's been much more prescriptive.
No, and actually in South Africa, that's something we're going to be turning to when we get to our South African team. But before we do that, can I ask David for a similar overview? As I understand it, don't go to work if you can work from home, but if you can't work from home, go to work. Does that about sum it up?
Yes, that's exactly right. I don't know why you needed me on the webinar, Chris. That's spot on. So we went into the lockdown in the UK formally on the 23rd of March, so a similar time to you in South Africa. And during that time, most businesses have effectively been closed. And where employees can't work from home, companies have been using what's called the Furlough Scheme. And that's a scheme where the government pays 80% of employee salaries whilst they're at home and doing no work. But from today, there are some slight relaxations to the lockdown, although it slightly depends on which of the 4 nations of the UK excuse me, you're in. And that's quite similar to Europe. So the lockdown has started to ease a little bit earlier as of last week in lots of European countries, but in accordance with guidance from the EU, the return to work is expected to be gradual. And that's the same in England, certainly. So people who are able to work from home should continue to do so. But for those industries where working from home is not possible, so factory workers, delivery drivers, and those workers are now encouraged to return to work. To facilitate that return to work, UK government has produced a set of 8 guidance documents, so one for different workplace locations. And a bit like Nicola was saying for Hong Kong, that guidance is not legally binding, but it sets out the government's very clear expectations how employers should organise a return to work. And 2 of perhaps the more relevant sectors for your clients, Chris, might be the offices, which would capture professional services, so the guidance for offices, and then guidance for factories, which would capture, say, manufacturing. And there are differences between the guidance, but there are some common themes, which I'll just mention briefly. So starting point, employees should continue to work at home where possible. If that's not possible, they should go to work but be socially distanced, which in the UK means 2 meters apart from one another. Those distances vary slightly across Europe. Only if social distancing is not possible should the employer then implement what's called mitigating arrangements. So things like screens between employees, fixed teams, or people working back to back or side to side rather than face to face, for example, on an assembly line. And if those mitigating arrangements are not possible, then the government says, well, there are real questions here about whether you should be reopening at all as an employer, because you do owe an obligation to take reasonable steps to keep your workers safe. So a bit like in Hong Kong, all employers are expected to conduct an impact assessment. So some sort of assessment doesn't need to be in writing, but assessing the risks of contracting the virus in the workplace and what steps have been put in place to mitigate those risks. And that risk assessment needs to be prepared in consultation with trade unions or an elected employee representative, and you are expected to give the results of that impact assessment to the employees and to publish it on your website if you're a larger employer. So the sorts of things that I think we're expecting clients in the UK to do is things like increased hand washing facilities, staggered start times, restricting the use of communal areas, one-way systems, limiting visitors, increased cleaning of commonly used equipment or door handles, and ensuring that if there's lots of deliveries that happen in your workplace, so materials that are delivered throughout the day, those should be dropped off in a sort of neutral zone rather than be handed person to person. Just quickly on PPE, there's no requirement under the guidance for employers to supply additional personal protective equipment like masks to employees if they're not normally used in the workplace. But if employees want to use their own face covering, so something that they make at home, for example, so distinct from formal PPE, then the guidance says that employers are encouraged to support that. And as you would expect, there are special rules for employees in vulnerable groups, so people with pre-existing medical conditions, those who are shielding, pregnant women, for example. And just finally, there's been a little bit of criticism of guidance because it says nothing about commuting. And one of the big worries for UK employers was whether they were going to have to make an assessment of how safe it was for employees to actually get to the workplace, for example, by relying on public transport, which in places like London, it is obviously used very frequently. And the government has really not addressed that question at all. It's encouraging employers to ensure there are additional car parking or bike spaces so that people can get to work without using public transport. And that's consistent with what's being said in the EU. But there's actually no requirement for the employer to assess the safety of someone getting to work. And I think there might be some significant issues that arise from that, particularly if trade unions start to get involved and say it's safe to get to the workplace.
That's absolutely brilliant, David. Thank you very much for that overview. And you raised the point you flagged there about public transport. I think we're going to be talking about in the South African context specifically. I see Nicola's nodding because no doubt it's a major concern in Hong Kong too. But let me go to Lusanda. I'm hearing a lot about guidance and encouragement and best practice. Here we're dealing with something quite a bit more onerous and rigid than that. But won't you just sketch the sort of the environment in South Africa that employers are facing?
Yeah, in South Africa, we definitely don't have guidance and best practice. We have rules that we're required to adhere to. As of the 1st of May, we have moved from our level 5 lockdown, which only allowed those in essential services to work, but now with effect from the 1st of May, we have those in permitted services also allowed to work, and there are certain permitted services that are regulated. And as Nicola and David have mentioned, we're also encouraged to have a phased return to work.
So Lou, I think your school children are taking up your bandwidth. Lou did express a concern when we started that might happen, but depending on when you come back on, maybe Talita, you can sort of pick up there, because Lou was just describing the specific regulation and moving from level 5 to level 4. You can just pick it up on a slightly different point too, which is specifically, how do you know? I mean, how many are industries? Not all industries are being encouraged to go back, although perhaps many employers will be thinking, trying to look ahead to a time when they will fall into the category of permitted industries. Lou, back, I've passed on to Talita because you were bumped off your system by your children.
Lou, jump in if you want to. Yeah, so we have moved from level 5 to level 4. And we have now essential services that are permitted to be back at work, and we also have permitted services. And these 2 categories of services are set out in the regulation that were passed on the 29th of April. And yeah, you know, it is clear, but it is also vague. So there is a lot of interpretation that goes into it, but yeah, those are the places where you will see if your business is a permitted service or is an essential service. From a safety perspective, there are 2 documents that are very important, and the first is the Occupational Health and Safety Directive that was issued on the 28th of April, and then of course also these new alert level 4 regulations that were published on the 29th of April, as I said. And in terms of the directive, the employers are required to take various measures. Firstly, administrative measures. It needs to, as in the UK, do a risk assessment. That doesn't need to be done in consultation with union representative or elected representatives, but it is good practice, of course, to so. That risk assessment must be provided to your Health and Safety Committee and the Department of Labour if the employer employs more than 500 employees. The employer must also prepare a policy to deal with these items that are dealt with in the directive. And also importantly, the employer needs to designate someone as their compliance officer for COVID-19. The social distancing and health measures are very detailed. Cloth masks must be provided, at least 2 to all the workers, and they must wear it at work. So yeah, quite apart from the position in Hong Kong, here, as Lusanda said, it's regulated and there are rules that you need to abide by.
I just want to pick up on a point, and either Lusanda or Talita, whichever of you wants to jump in there, if you feel free to. Either Nicola or David made the point, I think it was David made the point about special categories of workers or workers with vulnerabilities. One of the things that employers will be wondering is, if you know who is or is not, does or does not fall into a vulnerable category, and how is that? How do employers go about that? Do either of you want to come in there, Lou?
in terms of vulnerable groups, there's two major ones, those with so-called comorbidities and those who are over 60. And there's a list in terms of what are suggested comorbidities, and the employees in that category is in terms of health, and then the over 60s is in terms of age group. So those are the two guidelines for us in terms of the at-risk groups.
And how do we know what to do? Are those people not allowed to come to work, or are they allowed to come to work, but with, I don't know. Employers will be grappling with this, and I think 60-year-olds and up will be grappling with it. I want to go to work, and I'm in a special category. Do I get issued with 4 face masks instead of 2?
But there's nothing in the regulations that say that people with comorbidities and people who are older than 60 may not come to work. The substantive parts of the regulations are clear, that what is required are special measures to be taken in respect of these categories of employees. So if you look at what are ordinary measures, that would be a cloth mask, it would be limitations on face-to-face meetings, it would be social distancing and ensuring adequate space between employees. Of course, where employees are able to work from home, you must work from home. This virus is contracted through social contact. So where we can limit that as far as possible, that is what we need to do. So those are ordinary measures. Special measures would be things like a prohibition on face-to-face meetings for employees in those categories. It could be additional personal protective employment, so a mask plus one of those visors. It would be removing someone from a shared space and putting them in their own office, if possible, or it could be assigning someone like, a public-facing role to a back office role. Those are examples of what special measures would be.
I guess that leads to an interesting question about how we know the comorbidities, as you describe them, of our workforce, and what we do with that information. And maybe perhaps, Nadine, that's a good point, just to bring you here and tell us, what does all of this mean about the way in which employers, both what information employers are required to now manage in connection with their employees, and how that is managed or protected? Are there any special considerations we need to think about, employers are going to need to be aware of? You're still muted, Nadine.
Sorry, Chris. Yeah, I think a lot of employers anticipated the implementation of the remaining provisions of the Protection of Personal Information Act on the 1st of April. However, to date, these provisions have not yet come into force. And it's understandable that the government is, their primary focus is on measures to be implemented to flatten the curve. However, having said this, a lot of personal information is being processed. For example, the regulations provide for mandatory testing to take place. And as mentioned by Talita, employers establishing a list of individuals who may suffer from underlying health issues. So whilst the remaining provisions of POPIA have not yet come into force, the information regulator has issued a guidance note last month in which it did require that the regulations be implemented in conjunction with your lawful conditions to the processing of information. So employers should still comply with these conditions, which include processing the information for, in a reasonable manner for lawful purpose, and only for the specific purpose of preventing the spread of COVID-19, to make sure the information is complete and accurate, to only retain the records for as long as is necessary to curb the spread of the virus, and thereafter delete the records. And also, I think importantly, to put in place security safeguards to protect the confidentiality and the loss of personal information. So whilst the Act's not yet in force, employers are encouraged to still comply with these conditions of lawful processing. I think if I can go into just briefly, as you mentioned, there's two important aspects in the regulations and the directions which deal with the processing of special personal information. And the first is what Talita mentioned, which is creating a list of employees that suffer from underlying health issues. Arguably, employers will have to request this information from employees, but there is no specific disclosure requirement on employees to disclose. And ultimately, the general rule that an employee's informed consent is required. So employers should, explain the purpose for which it is required, and also explain that if they're not willing to make the disclosure, the employer may assume they don't have any underlying health issues, and that safety measures in respect of that employee may not need to be put into place. So that's the one aspect. The other aspect is this issue of testing, which is a slightly different position to the disclosure. The regulations do provide for mandatory testing. And whilst employers don't have to implement the testing themselves, if an employee has been in contact with someone who's tested positive, the employer will have to, escort the employee to be tested or to a testing site, which a qualified medical practitioner can then do the testing on the employee.
So, I mean, Nadine, one of the questions that I'm now starting to deal with, the questions that are coming through on our chat, on our Q&A rather. What is the extent of visibility? Ordinarily, workplace, we're familiar, certainly in this country, with transparency. Workplace, employment equity plans, other forms of workplace plans are subject of consultation and are typically shared and in a transparent way with the workforce. Does that extend to a list of employees with comorbidities, the list of employees who are over 60, and so on and so forth? How do we manage that sort of information?
Well, I think when you create the list of employees who are over 60, and specifically those who suffer from underlying health conditions, those lists shouldn't be provided generally to employees. And when creating them, you should try not use the employees' names, but rather the employees' numbers, as it is special personal information, your health information, and because the actual list is open to inspection by your labour inspectors. There's also the other side where there are mandatory reporting obligations. So in the instance where an employee has tested positive, an employer has to cooperate and report the matter to the Department of Health and your Department of Employment of Labour for purposes of your contact tracing measures that have been put into place. So there is some legal obligation to report certain special information, which would be allowed, but otherwise the general principles relating to the processing of personal information should apply.
Thanks very much, Nadine. Then I've got just a few questions I'd like to just cover while they're coming in. Two things: the 500 employees. I think, Talita, you mentioned that that the requirement to report to your health and safety plan to the department applies for workplaces with more than 500. Are there any other obligations that are triggered? There was a time when the regulations were being drafted that there was talk of mandatory testing at the workplace or temperature testing and things like that for different categories of employer. So can we just deal with that? And then perhaps, Lou, you can try and answer the questions that I'm getting about masks. And that is the requirement to wear face masks in the workplace something that applies to private workplaces as well as public? And is there a requirement that you wear masks as well as retain social distancing? So, for example, 2 meters apart and a mask, or are these either ors? So maybe we can just deal with those 2 points. To the 500 sort of number, what is it telling us? And are there any other obligations on employers with more than 500 employees to either test, take temperatures, or take special measures?
Yeah, so there isn't a blanket obligation on employers to do the testing, but we're talking about employment law, so there's always a but. In the mining industry, there is that obligation, and in those industries, there are normally clinics on sites and registered medical practitioners, and therefore it is possible to do the testing at those clinics. Where there is also a distinction between small versus medium and large businesses is in the annexure to the regulations that deal with workplace plans. And the plan is quite detailed in respect of what a medium and large business need to include in their plan. And it recognizes that a small business might have different circumstances and they can adapt their plan accordingly. But
just to be clear, Talita, the workplace plan is not something that's required to be submitted to regulatory authorities. That's different.
No.
That's the occupational health and safety thing for over 500.
Well, the workplace plan must be available for inspection at the workplace, so it doesn't need to be submitted somewhere on a website or at an office, but it must be available for inspection. And the employer's policy and its risk assessment, if you employ more than 500 employees, that needs to be made available to your Health and Safety Committee, as well as the Department of Labour.
Okay. Thank you very much, Lou. Masks. Do you have to wear them even if you're maintaining 2 meter social distancing? I heard David talking about working side by side or back to back instead of facing each other. Are masks obligatory? And you said 2 masks have to be issued. Are there specific regulations about cleaning facilities for masks, which were certainly in some of the draft regulations?
So yes, the wearing of masks is obligatory in terms of the South African regulations, as is the social distancing of 1.5 meters apart. So employers are supposed to make sure that their employees do both, not either or. It does apply to all employers and all workplaces, so not only private employers, it does apply to all the workplaces. The masks, the obligation is on the employer, yes, to submit and make sure that each employee has 2 masks, but also the obligation for the cleaning of the masks, and the cleaning of the masks, etc. The regulations put that obligation on the employer themselves and not on the employees to ensure that the masks are cleaned.
Okay, so I just want to flip back across to the experience in Hong Kong and the UK, and the answer may simply be that these are regulating to this level of minutiae. But some of the questions are coming through in the Q&A saying, but wearing of masks can influence your ability to do the job. It might muffle the way you speak. A receptionist wearing a mask, it might not be able to perform to the standard he usually does. Are there any guidelines that have come out? I mean, I think, Nicola, the answer is probably going to be no, because certainly in your immediate environment, but what about are there any jurisdictions around you which have more formal requirements of that kind that you are able to talk to? And then I'd like to hear from David about the UK regulations.
You're right. So there aren't any specific rules in Hong Kong. And so employers are having to just decide on their own risk assessments what they do to ensure the safety of employees. In China, there have been more granular regulations and rules introduced by local authorities and also sector-specific rules and guidance. And part of that was wearing masks, so issuing masks to employees, ensuring social distancing 1 meter apart, temperature checking employees at least once, or for construction industries multiple times in the day. But the rules didn't go so far as to then talk about, but there are exceptions where that would impact an employee's ability to do their job. It doesn't go that far. And I suppose interestingly, it sort of plays into this as well, but talking to colleagues in China, it seems that actually practically complying 100% with all of those requirements is actually really difficult for employers, and obviously more difficult depending on the nature of the work that's being carried out. And so employers were struggling to comply entirely, and so we're sort of taking a fairly practical approach to the rules and the guidance. And that then also the government weren't taking a strict approach on enforcement. And so that perhaps that plays into the practical point. But specifically to your answer, to your question, no, there haven't been any rules or regulations specifically to that point about exceptions where it impacts the individuals' ability to do their job.
David, your regulations out yesterday, do they tell us anything about this that we might find useful?
No, sadly not. They as I mentioned, they say that there's no requirement to have people wear masks in the workplace. If an employee wants to, then that should be supported by the employer. And what that means, according to the guidance, is that you make it clear to the employee that they should wash their hands when they take on and off the mask, that they are responsible for washing the mask regularly. The employee is, it's not the employer's responsibility, and that they should avoid touching that, touching the mask and then touching other parts of their face or communal areas. But that's very much in the context of this all being guidance, as I said, and not mandatory at all, because I absolutely can see the point that you're making from the Q&A, that if this inhibits someone's ability to do their job properly, it leaves the employer in a bit of a difficult situation. But the answer, certainly from a UK perspective, would be, well, you as the employer need to take some steps to be flexible with the employee, and I can't imagine that you'd be in a position where you could take any sort of action against the employee because they're incapable of doing their job to the required standards because of a mandatory rule issued by government.
Thank you, David. I think we'll just come back to Talita and Lusanda with a few questions that are dealing with this. I think our participants are very anxious in the first instance about the requirement of disclosure of comorbidities, as they're called. The first question is, typically we're used to an employer not being entitled to insist on knowing about medical conditions, and typically there's a high degree of confidentiality by which, for example, employers would, usually it would be medical doctors that would be able to engage with employees, and there would be a level of distance between what employees communicate directly to their employer. But it appears that here employers are not only permitted but actually required to establish these medical conditions so that they can take appropriate measures. And then sort of a related question, I suppose, is, and we must just ask it, is COVID now treated as an occupational disease? Is this something which is considered to be a workplace-related disease? Talita?
I'll deal with the first question and Lou can deal with the second question. Chris, I think there's an important distinction to make between the disclosure of your symptoms and being COVID-19 positive and you having underlying medical conditions. In relation to the first one, where you are suffering of symptoms, fever, coughing, loss of smell, loss of taste, that kind of thing, you need to tell the employer, and that duty arises from the employee's duty under the Occupational Health and Safety Act to ensure a safe work environment. The employer must then isolate that employee, so take that employee out of the communal areas and make arrangements for that employee to be transported either to their home or to a site where they can be tested, but to self-isolate. That is an obligation to disclose. So if you have those symptoms, you need to tell the employer. And
just while we're talking about that, because there are a few questions on this, Talita, if you don't mind. Sure. How do you, transporting somebody who has got symptoms, a company driver with a mask, special arrangements, it sounds like a high intensity kind of public health method of transport rather than the company driver that should be driving somebody off to wherever they're going.
Yeah, look, the very first thing you do with that employee is give them a surgical mask. So the employer must not only have a stack of cloth masks, must also have a stack of surgical masks that that person can then put on. If the employee came to work in their own car, I can't see any objection for requiring that employee to go in their own car to their home if they are well enough to drive, or to drive to a testing site. So that would be making an arrangement for the safe transport of employees. If that person is dependent on public transport, there might need to be other options, like your company driver with a mask, and the employee who is suspected of being infected also having a mask on, hand sanitizer, all of those good things in those vehicles. Alternatively, an Uber, and sit back and make sure, you know, that you do not have too close contact with the driver sitting in the front seat, for example.
Yeah.
So this would be, I think, reasonable arrangements to make in relation to transport.
Lou, you were going to talk, I can't now remember which piece of that, Talita.
Chris, can I just go into verse 2?
Yes.
That is the disclosure of underlying illnesses.
Yes.
Because you do not have, you cannot force an employee to make that disclosure. You need to explain to the employee why you need this information, that there is an obligation on the employer to ensure a safe workplace also for that individual who may have these underlying conditions. And you are only going to be able to make those special arrangements if you know that that person has that underlying condition, and therefore ask the employee to make that disclosure. But if the employee does not want to consent to that and want to make that disclosure, I don't think you can you can discipline the employee, for example, for not making the disclosure. And
the flip side of that, some questions coming through saying, well, you know, normally we ask for a doctor's note. Does an employee who makes a disclosure of an underlying condition have to prove it? Or do we just be operating on sort of, it is what it is type of a situation?
Yeah, there's no obligation to provide a doctor's note in the regs. So I think you don't need to insist on a doctor's note. If an employee feels the need to provide you with proof that they are suffering from a particular illness, then you know, the employee can provide that. Also, it's not all illnesses. It is illnesses specific to the way in which this virus affects the body. So it would be people who have compromised immune systems, lung disease, heart disease, things like asthma, hypertension, those kinds of things that, should the employee contract the virus, the risk of serious symptoms and you know, a bad prognosis might be on the cards. So it's not me with my eczema. I don't need to tell you about my eczema.
Lou, I think the question that was being deferred to you was about whether this is now an occupational disease, or is it something which is treated as a workplace illness, or does that matter? Is there a specific answer to that question?
Chris, I'm not aware of being officially declared an occupational disease, but I think it's definitely being escalated to a very serious workplace affecting disease, but as opposed to it being officially declared.
Yeah. So, I mean, maybe that's the reason for that question, and a number of questions lead into this one, which is an important question, and concerns employer liability. Some people are talking about, well, is an employer vicariously liable? And I think that's a topic that I'd like to bring in to get a view from Nicola and David in their jurisdictions. But let's just ask here, an employee who contracts COVID and says, I believe that I contracted this from my interactions in the workplace, because for whatever reason, that's where I think I contracted it, and I'm now going to hold the employer liable for that in some shape or form. Are employers expecting to receive, should they be expecting to receive claims in negligence if they don't comply with the regulations? and somebody needs to put up their hand, either Lou or Talita. Nadine, you're not limited to answering questions about information.
Chris, I think the difficulty here for employees will be the sort of burden of proof in that they contracted it in the workplace. You know, that's one hurdle they will have to sort of overcome in order to establish liability on behalf of the employer. I mean, from a cautious approach, if an employee does test positive and has been at the workplace, the employer should ultimately comply with the provisions of COIDA, fill in your, necessary forms, report the disease, should there be a claim that the employee can make to the fund for compensation. In terms of general liability, I know that there are certain offences established by the regulations, that require employers to comply with the regulations, otherwise they may be found guilty of a fine. But there is also a provision in the National Disaster Management Act that actually states that when someone is complying with obligations that have been developed under the Act, and they're doing so in good faith, there should be no liability attached to that. That provision hasn't yet been explored, but it may provide guidance in this regard going forward.
Can I, Nicola, ask you to comment? I don't know whether you've had any thoughts or experience in Hong Kong or else seen this elsewhere in Asia, that there's any sense of employers having some additional liability. But perhaps you can also then comment on the question that we haven't raised, but has started to come up in some of the questions about turning from the physical risks of incurring this disease or suffering in health versus the risks of mental health that many people have been talking about for their as a risk in the workplace.
Yeah, sure. So on the first point, it sounds similar to what's happening in South Africa, in as much as COVID-19 is a notifiable disease. So it means that health authorities have the obligation to notify of suspected or confirmed cases, although in Hong Kong that obligation doesn't extend to employers strictly. And COVID-19 also hasn't been listed as an occupational disease. So unlike SARS, in relation to the outbreak back in 2003 in Hong Kong, which was listed as an occupational disease, COVID-19 hasn't. And I think that's largely in Hong Kong because there hasn't been a large workplace outbreak. The cases we've seen in Hong Kong have been largely community transmitted or returning residents and travellers to Hong Kong. And so because it's not an occupational disease, employees can't bring claims under the Employment Compensation Ordinance for contracting it at the workplace. And so therefore, like Nadine was saying, you'd have to look or identify some form of breach of the employer's duties under health and safety, or a breach in sort of the implied, the general duty of care towards employees. So but then you have the issues of establishing that. But that, of course, goes into how employers are approaching this in Hong Kong in terms of risk assessment, with a mind to their duty to take all reasonable steps in order to provide a safe working environment for employees. The second point about mental health is really important, and I know that we were, in preparing for this, we're discussing, like, the focus is often on the physical side, but it's also thinking about the sort of the impact this has on the wider employees' well-being. And I think in Hong Kong, the way that that's being sort of addressed in terms of during a lockdown or during a working from home situation, in terms of really thinking about how best to keep in touch with employees, keep them motivated, keep morale up, to acknowledge and try and facilitate where it's actually really difficult to work from home for a long period of time. Sadly, people having loved ones who are sick. And I think that then, when planning the return to work, employees in Hong Kong have been thinking about that. And so in particular, thinking about whether certain provisions need to be made for vulnerable employees or employees who are finding it very difficult to return to work. And I suppose just thinking generally about additional measures away from the masks, hand sanitizers, social distancing, but those extra measures that will make sure that it's a successful return to work supporting all the employees that are part of that workforce.
Thank you very much, Nicola. David, I mean, there's sort of follow on from that, but there's two, apart from the mental health aspect and what attention it's getting in the UK, and some of our questions here raise an issue that we've increasingly been grappling with, is where people work at home, does that become the workplace, and does the employer now have responsibility also for the health and well-being, including in relation to the contracting of any disease, or the mental health and well-being of employees while they are at home?
Yes, I mean, just taking those questions in reverse order, I think the answer to your second question about people working from home is a clear yes. The health and safety rules in the UK continue to apply in the same way, where someone is working from home. So an employer has an obligation to ensure that people, that its employees are safe when at home. Now that typically just extends to ensuring that they've got a proper home office set up, that they're monitoring for neck strain, eye strain, things like that. Ordinarily, in non-COVID situations, the employer has an obligation to ensure that a workstation assessment takes place. That's obviously not really practical at the moment where people are social distancing. So there's been quite useful guidance issued by some advisory groups in the UK that help employers to understand how they should implement this obligation now, which effectively involves ensuring that there's proper training delivered to employees electronically, that there's proper guidance about how to ensure you've got a safe setup at home. The mental health thing has had a real focus in the UK from employers. I agree with everything Nicola said about the pressures of being at home, and won't add to that. But the one point I would mention is about the return to work and the anxiety of the return to work. So I have clients who are starting to think about, well, how do we deal with the pressures of returning to work, where people feel unsafe on public transport, where they feel unsafe being in the office, even if they're having to wear a cloth mask in as you are in South Africa. How do you deal with the mental strain of that, and ensuring that there is additional resources available, employee assistance programs, counselling services, and webinars on managing anxiety and stress. So a real increase in that sort of provision in order to protect mental health.
Those are really great points, and they lead into, again, some questions being asked which are a little bit like, I want to come back, Talita, not to forget it, about the list of diseases which some people are asking that we just restate what is a comorbidity, and also some sensible suggestions coming in on the Q&A line, including, I think, Kim Butler saying, well, you can disclose that you fall into a category without disclosing what the underlying reason is that you fall into that category, as a way of managing some of the confidentiality issues that we were discussing earlier. But one of the questions is, and it perhaps flows from this, it's accept that there will be a high degree of anxiety for some people about returning to work. I mean, we actually we're probably experiencing two categories, and maybe there are many more categories of staff who are actually desperate to go back to work because getting back into that environment is really what they need from a mental health perspective. But then there are also deep anxieties about the risk that is exposing employees to of contracting the disease. And so a question coming up, can we even force employees to go to work? Assume we resume business and we're in a permitted industry, and the employer announces we're going back to work, we've got our 2 cloth masks and so on, and staff say, I don't want to because I'm concerned about contracting the disease. Can we force them? Force is an interesting word, because use force, I would say no. And I assume the question means require in some legal sense, or can they say, sorry, I'm still out?
Yeah, require, instruct, and discipline if they don't. That's the question. I think as long as the employer is complying with its health and safety obligations, it can require them to come back to work. and that it could then actually discipline an employee who is not adhering to that instruction. But I think one would need to understand fully the employee's complaint and listen very carefully to what the employee has to say in that regard. This would obviously only apply to employees who cannot work remotely and who must be at the office in order to do their work, or at a factory or at the manufacturing site. The list of comorbidities. Yeah, this is by no means an exhaustive list, but people on cancer treatment would be on that list. People with TB, HIV and AIDS, other lung diseases like severe asthma, heart diseases, hypertension, and you would probably also include your pregnant employees.
I see, and the time has slipped away very rapidly. It's 11:02, and some of our participants are leaving. If you will allow me to ask one or two final questions before wrapping up, that would be great. Can we just do that, and then I'll wrap up by 5 past, if that's okay. Just the what follows from. I think we dealt with that question already. I wanted to go back to the point about masks. A lot of people are asking that question in the South African regulations. It does cause a bit of a stir, the extent to which people either have to wear masks or not. And can I just ask this question? Is this very specifically regulated, or are we just going to have to make it up as we go along? Is it regulated differently for big, small or medium employers? And when we get down to details about washing and these kinds of things, are we going to be able to read the regulations and can say to clients, look at regulation X, Y, or Z, or are we simply interpreting the general obligations that employees have? Lou, I don't know if that's something you want to just supplement. You raised it earlier.
I'm going to throw it to Talita to supplement, but what I did want to steal this time for is just clarify in relation to the question you asked about it being an occupational disease, and that in regulations it does talk about it being contracted in the workplace, and that if it is contracted by an employee as a result of occupational exposure, that a claim must be lodged in terms of COIDA. So it has been recognized, and that way it's contracted in the workplace, there must be a COIDA claim that's lodged. Over to you on masks, Talita.
So you must provide at least 2 masks. That is a must. And it's cloth masks. Some are branding their masks. So this is a marketing opportunity as well. And then the regulation says an employer must make appropriate arrangements for the washing, drying and ironing of cloth masks.
Make appropriate arrangements. So yeah, I think we're going to leave our guests hanging on that one. I don't think we're going to tell them what that means.
Well, I don't think, and I mean this is now an interpretation, but I don't think it means I need to go buy a washing machine for my workplace. If I have a box of Omo, employees are able to wash their masks at the workplace in a basin, that is fine. If you say to employees, please, this is the way in which you need to wash your masks at home, that would be making an arrangement. But what I need to do is to make sure the thing is clean when they put it on, because you don't want to now get all kinds of other germs.
Thank you very, very much. It's 5 past. I said I would wrap up now. This conversation, I suppose, it evolves all the time. This is uncharted territory. Some extraordinary questions we're actually discussing as employment lawyers, particularly this kind of thing. But some of the themes that we've talked about, which deal with, I mean, there seems to be no doubt that employers are facing far more onerous or far-reaching obligations to think about health and safety and to think about things which traditionally, you know, the seasonal flu in the workplace was not something which employers treated as a matter that needed a high regulation. But we're now dealing with a disease and a pandemic that is pushing obligations further and deeper into the workplace for employers to maintain health in this instance, probably for good public health reasons. But thank you very, very much to Nicola and David for sharing your insights from Asia and the UK. It sounds to me as though in all of these areas we're going to have to continue, both as lawyers helping our clients and as employers, making things up a little bit as we go along. And I think you won't envy us and our clients in South Africa who are facing obligatory or mandatory regulations, and you'll probably be much happier reading guidelines and best practice directives rather than obligations or regulations that could result in criminal prosecutions or being fined. Anyway, thank you very much for your participation. We'll put a copy of this on our website. Thanks to Talita, Lou, and Nadine as well, and to the organizers. And thank you most of all to participants for signing up for this. Goodbye.